I was at, we had pre-sentence reports over and over again. There were things in there that were sensitive, sometimes reflecting somebody who were putting their lives on the line to even give a report. Neither the defense counsel nor I as a prosecutor ever thought those would be made public. And we assumed the judges, we had judges across the political stripes who read them, kept the confidence of that. As a result, we knew that the reports were thorough. And a judge has the final say, but as a prosecutor, I might have a recommendation, but I never question a judge who might give a different sentence, because my responsibility was to prosecute, theirs was the sentence.
Senator Lee.
Yeah, might I just weigh in here? I totally understand the concern that you're describing relative to the confidential nature of pre-sentence reports. As a prosecutor and as a law clerk, I reviewed those with some regularity, and I understand the sensitivity of them. Let me suggest a couple of things. First of all, it's not unusual for us as a committee and as members of the United States Senate to review materials that would be inappropriate for public release. I don't think one of us is suggesting that. There are means by which we can review things in a classified environment and treat them as classified. We've done that with significant success in this hearing. Secondly, to the extent that wouldn't provide the level of comfort necessary, we'd also be happy to review them on a redacted basis. These are things that have become relevant in our conversations. We want to make sure that we have the facts, but not one of us wants to endanger anyone or to render public information that is sensitive in nature. There are abundant ways around that.
I would suggest that the information contained in these reports is dangerous to the victims and to the innocent people who are mentioned in these reports, and unnecessary at this point. It's never been requested by this committee, and it's merely a fishing expedition in dangerous territory. Classified settings, redacted versions of the reports. This has never happened in the history of this committee. And I would say, Senator, I will just tell you, I am not going to be party to turning over this information and endangering the life of an innocent person for a political quest to find more information. We have exhausted this topic, and we've gone to it over and over again. And I think that this is a bridge too far for this committee. That's my personal feeling. I take it that Senator Leahy may agree with me in that regard. This nominee has been before this committee for 18 hours. I don't believe that this information is going to change anyone's vote. You can decide in your caucus what you want to do to go forward. I've told you my position. I want to proceed if I can. I thank the nominee for waiting for this colloquy, and I turn it over to Senator Cotton.
Judge, I want to return to the question of crime and specifically sentencing. In any of the cases where you've sentenced an offender below the guidelines, has that offender gone on to commit another crime after getting released from prison?
Thank you, Senator. When judges sentence, they often impose terms of supervised release. And there are times in which, when a person is on supervised release, they reoffend. There are also times when they don't. But even after the period of supervised release, the court doesn't continue to have any way of tracking or knowing what happens, because if they were to reoffend, it wouldn't necessarily come back to the same court or the same judge.
So you don't have a factual basis to know whether or not anyone you've sentenced below the guidelines has reoffended in the future?
Do I have a factual basis? I know that there are people who have reoffended while on supervised release. I can't remember whether any of them were guideline sentences, below guidelines, or above guideline sentences.
Okay. I know you've answered a lot of questions the last 2 days about sentences and sex crimes. I just want to be exact about this. In these cases, have you ever sentenced an offender above the guidelines recommendation?
I'd have to take a look at, I know that I have sentenced offenders to the guidelines if in the category of sex crimes in general. I know that I've given 30-year sentences for at least one offender, almost 30 years, 29.5. I've given, I believe, a 12-year sentence for someone at the agreement of all of the parties, which was a sentence that was a part of his plea agreement. I'm not remembering the others.
I understand you've sentenced in a lot of cases. I want to return briefly to the Hawkins case. Wesley Hawkins, as a reminder, was convicted of a child pornography offense in 2013. The sentencing guidelines for this offense called for a sentence of 97 to 121 months, or 8 to 10 years. The prosecutors asked for 24 months. You sentenced him to 3 months. We've heard a lot about this case and your 3-month sentence of Wesley Hawkins, but you got another crack at him in 2019, Judge. In 2019, you sent Wesley Hawkins back under conditions of confinement with the Bureau of Prisons for 6 months with additional restrictions on his computer usage. That's twice the amount of time in custody that you sentenced him to in 2013. What did Wesley Hawkins do in 2019, Judge?
Oh, I don't remember, Senator. I have a lot of defendants who I've sentenced who are on supervision, who violate conditions of supervision. If in our system, someone like Mr. Hawkins, especially given the crime, the egregious crime that he committed, was likely on a very long period of supervision. And during that time, he would likely be under computer restrictions for 10, 20 years or something, where he's not allowed to do certain things with a computer. And a probation officer is monitoring. They put software on the computers of individuals who are who have these kinds of conditions imposed, and that restricts their ability to access certain information on the internet. And so it's not uncommon for a probation officer to report violations of supervised release, not just in this area, but across all crimes. And then the court has to determine how to handle that. And you could, in fact, send someone back to jail for violating conditions of supervised release that are not themselves criminal behavior. It's just, you know, the court says in their supervision order, I'm imposing a 20-year or whatever it is sentence of supervision, and during this time you're not allowed to access your computer, et cetera, et cetera. So if he were to do that, it wouldn't be additional criminal behavior, but it would be a violation of my order. And when he comes back to the court on violation, the court has factors that we look at to determine whether or not to treat that essentially as the kind of violation that would require him to go back to jail.
Okay. Judge, yesterday we had an extended conversation of your sentencing of a man named Keith Hodges, a fentanyl kingpin. That sentencing occurred in 2018. You had very detailed recall of that sentence. To my knowledge, that's the only time anyone's asked you about Mr. Hodges' sentence. You've been asked repeatedly over the last 2 days about the Hawkins case. It's been in the news, as Senator Durbin decided, for days on end. This resentencing happened in 2019, and now you're saying you don't have any recollection of it. Let me see if I can refresh your recollection. This is the order you signed, Judge, on April 17th, 2019, in USA v. Hawkins. And it says that you concur with the recommendation of the probation office to return him to a residential reentry facility for 180 days and to engage in various kinds of computer monitoring and computer monitoring and search. There's your signature over there, Judge. You really don't remember what?
Senator, that is a very, very common thing that judges do. I've sentenced over 100 people, and supervised release, which is the kind of post-incarceration condition that judges ordinarily impose, is something that's done on a standard form, which is what that is.
I understand you've done a lot, Judge, but
And-
none of them have been the centerpiece of your hearing for the last 2 days. Do you really expect this committee to believe that you don't remember what happened in this Hawkins case when it came back before you?
Yes,
As
Senator,
Senator-
I do expect you to believe that's my
Well,
testimony.
I don't find it credible, Judge. It's been in the news for days. Senator Durbin has cited it being in the news for days. You've been asked about it probably more than any other case you've ever had. And I just don't find it credible that you weren't prepared for that matter in 2019. You know what I think? I think he got caught with child pornography again, and he wouldn't have if he had been in prison for the 8 to 10 years the guidelines called for in 2013 when you first sentenced him. Let's turn, though, to your work for detainees at Guantanamo Bay. First off, let me just ask, do you think most detainees at Guantanamo Bay were mostly terrorists or mostly, I don't know, innocent goat farmers?
Senator, it's impossible for me to answer that question. The people at Guantanamo Bay had been accused by the government of engaging in terrorist activities and therefore classified by the executive branch as enemy combatants.
Okay, do you think America would be safer or less safe if we released all the detainees at Guantanamo Bay?
Senator, I'm trying to figure out how to answer that question. 9/11 was a terrible attack on our country, and the executive branch, pursuant to authority that the Supreme Court said it had, designated people as enemy combatants and sent them to Guantanamo Bay. The Supreme Court also said that anybody who was so detained could seek review of their detention. And as a federal public defender, my role and responsibility was to make arguments in defense of the Constitution and in service to the court that was trying to assess, based on the authority given to it by the Supreme Court, whether or not people were adequately classified, what the legal circumstances were, how these habeas petitions were going to be processed. This was a series of legal challenges in a novel environment that federal public defenders and lawyers across the country were engaged in helping the court to evaluate so that we can understand what the Constitution required in this time of emergency.
Okay, so no opinion on whether America would be safer or less safe if we released all the detainees from Guantanamo Bay?
Senator,
Okay.
America would be less safe if we don't have terrorists out running around attacking this country. Absolutely. America would also be more safe in a situation in which all of our constitutional rights are protected. This is the way our scheme works. This is how the Constitution that we all love operates. It's about making sure that the government is doing what it's supposed to do in a time of crisis. As Justice Gorsuch said, the Constitution is not suspended in times of crisis. The government still has to follow the rules. And so criminal defense lawyers make sure that in times of crisis, the government is following the rules.
Okay, let's turn to the actual cases. How many of these terrorists at Guantanamo Bay did you represent?
When I was a defender, 4 cases were assigned to me in our office. I don't know how many cases came into the office in total, but
You personally had 4.
I was assigned to them along with another defender who worked on the same cases. She was more senior. She did all of the sort of fact gathering related to the cases, and as an appellate defender, I worked on the legal arguments.
Okay. Did you ever represent any of the detainees at Guantanamo Bay when you were not a public defender?
One of the people who I'd represented while I was in a federal defender, his case got spun off and taken up by a law firm. Law firms around the country were also engaged in this work.
I'm well
at the
aware of what
time.
law firms were doing at the time.
Yes. And I left the federal public defender's office. I joined a law firm, and one of the people that I had represented was now at that law firm. They had him as a client.
That's Mr. Al-Salwam.
Al-Qatani
Al-Qatani was the one.
was the one who
Just coincidentally, both he and you went to Morrison and Foerster.
Yes, Senator.
Okay. What about Mr. Al-Salwam?
I don't know what happened to Mr. Al-Salwam.
You were listed as counsel for 2 years during your time at Morrison and Foerster.
What happens is when you leave from any place, firms or government service, you have to let the court know, or their records reflect where you are in the system, and not so much the case in terms of your address.
So to go back to Mr. Al-Qatani,
Yes.
He just coincidentally, it's a small world, went to Morrison and Foerster at the same time you did, and then you represented him, and you did file multiple motions on his behalf.
So I don't know if it was at the same time. I'm not sure.
But you did file multiple motions for him,
I only
2008 and 2009.
I don't recall whether it was multiple, but he was still at the habeas stage of the process. And I don't know when he came, because the partners who picked up the case were in Los Angeles. I was in Washington, D.C. They contacted me to say, oh, we see on the docket that you had previously represented him, and now you're with our firm. Will you assist us with looking at these briefs, working on these briefs? There were many lawyers who were working on the filings that you're talking about.
After you left the public defender's office, did you continue in your representation of any other client you had at the public defender's office?
I didn't continue my representation of any client. I left the federal public defender's office and then picked up Mr. Al-Qatani through the circumstances that I talked about, and there were no other clients that I represented in that way.
I have to say, that sounds like continuation. You represented him at the public defender's office, and then you represented him in private practice as well. And you're telling us that's the only person you represented at both the public defender's office and in private practice?
Yes.
So you didn't continue to provide any kind of pro bono work for murderers or rapists or anyone else, but you did continue to represent this terrorist at Guantanamo Bay?
When I got to the firm and they told me that the case was there, and they recognized that I was at the firm and had previously worked on the case, and by they I mean the partners in the firm, they asked me as a member of the Supreme Court and appellate group of the firm, which is what was my practice, if I would help review and work on some of the briefing that they were submitting on his behalf, given my familiarity with the case.
Were you representing him pro bono at Morrison and Foerster?
The firm takes on pro bono representations, which means that the person isn't paying. And
let's turn to your amicus briefs. You had 2 briefs in Guantanamo cases, one for a think tank, one on behalf of a group of former judges. I think, as anyone who's done amicus work knows, sometimes the client seek out the lawyer, sometimes the lawyer seek out the client. For either of those amicus briefs, were you involved in any way in seeking or recruiting those clients or suggesting the idea for an amicus brief in the first place?
no, Senator.
Were both of those briefs done on a pro bono basis?
Yes, because the Supreme Court and appellate group in a law firm has paid clients and also has pro bono clients. And the briefs that I worked on were on the one brief was 20 former federal judges who wanted to make an argument in the Boumediene case that was in the Supreme Court. And one of them was a partner at my law firm. She was a former federal judge whose idea it was, and she knew the other judges and wanted our group to work on the brief. The other was not just one think tank, it was the Cato Institute, the Rutherford Institute, and the Constitution Project, an ideologically diverse group of nonprofits who wanted to make arguments in another case that the Supreme Court had taken up related to these issues, because all of this was novel and a lot of issues were being evaluated by the Supreme Court regarding the scope of executive authority during this time of crisis.
Okay, so you've done pro bono work for or on behalf of detainees at Guantanamo Bay. Have you ever done pro bono work for the victims of terrorism?
Senator, I'm not aware of any such cases in my law firm. I was in a group of lawyers that was often approached to ask, would you file a brief for some group? And I'm not aware that any victims of terrorism asked our firm to participate.
Okay. So we've talked a lot about the people you represent. Let's talk a little bit about the defendants in those cases and how you characterize them. I'll remind you that those were the President, the Secretary of Defense, and active duty Army officers. Senator Graham and Senator Cornyn said that you called them war criminals. You disputed that, and Senator Durbin has repeatedly denied it as well. And I'll concede you didn't use those exact words. You didn't say war criminals. But you did say in multiple court filings that they committed acts that constitute war crimes. I'm sorry, but I got to confess, I don't understand the difference between saying someone is a war criminal and saying they've committed acts that constitute war crimes. So can you explain that difference to me?
Yes, I will. Thank you for the opportunity. So when you file a habeas petition under our law, you can't file it against the United States because of sovereign immunity. The way our law works, you have to file it against individual officers in their official capacity. That's the way in which you're able to file a habeas petition. So whoever is the executive at the time becomes the named party in the brief. And a habeas petition is like a complaint in a civil case. It's making allegations to begin the litigation about the person's detention.
But Judge, official capacity, personal capacity, all that is just a bunch of procedural gobbledygook. These are the people that you said committed acts that constitute war crimes.
With respect, Senator,
I just don't understand the difference between calling someone a war criminal and saying they committed acts that constitute war crimes.
With respect, Senator, they were not sued in their individual capacity. We weren't making allegations about those individuals. And in fact, over the course of the case, the names changed. So later on, the habeas petition became against President Obama because he then became the executive for the purpose of the habeas petition.
I'm well aware that names changed. It probably changed from Bob Gates or from Don Rumsfeld to Bob Gates as well. But they were not the ones in office. They were not the ones who were overseeing the government when you filed these suits and you said they committed acts that constitute war crimes. I don't understand how you expect this committee to believe that there's a difference between saying someone's a war criminal and saying they committed war crimes.
Thank you for the opportunity to explain, Senator. One of the allegations that had been publicly reported with respect to the group of people who were in Guantanamo Bay was an allegation concerning the use of torture. And when you make that allegation, you bring it under laws that themselves constitute crimes of war. That's the way in which the law works. So if you're writing a habeas petition and you say, upon information and belief, Mr. Al-Qahtani was tortured, that allegation is made under a law that says that there was a war crime that occurred as a result of that torture, and you're making that allegation against the United States, but because you can't sue the United States, the actual petition is named in the name of whoever's leading the United States at the time. So later in the course of this, it moved from President Bush, Donald Rumsfeld, to President Obama. It's not about the individual. It's about the allegation that that Mr. Al-Qahtani, upon information and belief, had been tortured in the lead up to his detention.
I don't know, Judge. Sounds like a debate about how many terrorists can dance on the head of a pin to me.
Thank you, Senator Cotton. Ask unanimous consent to enter a letter in the record from 9 former national security officials defending Judge Jackson's Guantanamo representation. The signatories include former Attorney General Loretta Lynch, Department of Homeland Security Secretary Jay Johnson, and the former Judge Advocate General of the United States Navy, Senator Booker.
Thank you very much, Judge. After me, only 5 to go. But sit back for a second, because I don't have questions right away. I actually have a number of things I just want to say, because this has been not a surprise, given the history that we all know, not a surprise, but perhaps a little bit of a disappointment. Some of the things that have been said in this hearing. The way you have dealt with some of these things, that's why you are a judge and I am a politician, because you have sat with grit and grace and have shown us just extraordinary demeanor during the times where people were saying things to you that are actually out of the norm. I had to go up dais to ask some of my more senior colleagues about what I feel like is a dangerous precedent. People are taking 1,000 cases you've been over. Is that right? I'm sorry, I said you wouldn't ask you questions, but just give me
Something like that.
something like that. And from what I understand is that these cases often take days, weeks, sometimes months, right?
To
To
decide in a case?
Yeah.
Yes.
There's a trial sometimes. And the folks are taking any of those cases and just trying to pick pieces out. And so my colleague, Senator Hawley, has been doing this all into the lead up and saying things, tweeting things that I think that a lot of us, when I was just trying to get some advice here, is this is what the new standard is going to be. That any judge coming before us that has ever chosen outside of the sentencing guidelines, below the sentencing guidelines, we're creating this environment now where I could make myself the hero of people who have been victims of some horrible crime and suddenly put whatever judge I want on the defensive by trying to drag out little bits when they have no context to the case. None of the facts. They're seeking to exploit the complexities of a criminal justice system, the reason why we have a third branch of government. I feel bad that there was a judge mentioned by name in this hearing that's from Senator Hawley's state. What is that judge going to think next time they have a complicated sexual abuse case that comes before them, and they know that they could possibly be called out if they go below the sentencing guidelines, which I showed you yesterday in my lack of chart. If you remember, I was uncharted. But that you are deciding completely in the norm. 70+% in many states of people are doing just like you did. But I'm a Democratic senator. I've never quoted from this very well-respected conservative periodical. This is the National Review. Very well-respected. They're not necessarily something I agree with all the time. But here's what the National Review, this is the title. Senator Hawley's disingenuous attack against Judge Jackson's record on child pornography. I'll just read the first paragraph. I would oppose Judge Ketanji Brown Jackson because of her judicial philosophy for the reasons I outlined last week. I addressed that in a separate post. For now, I want to discuss the claim by Senator Josh Hawley that Judge Jackson is appallingly soft on child pornography offenders. This is the kicker here. The allegations appear meritless to the point of demagoguery. I got letters from leaders of victims' rights groups, survivors of assault, all saying sort of the same thing with the National Review. Feel proud about yourself. You brought together right and left in this calling out of people that will sit up here and try to pull out from cases and try to put themselves in a position where they're the defenders of our children, to a person who has children, to a person whose family goes out in streets and defends children. I mean, this is a new low. And what's especially surprising about this is it didn't happen last year. You were put on a court that I'm told is considered like the second most powerful court in our land. And you were passed with bipartisan support. Nobody brought it up then. Did they not do their homework? Were they lax? Did they make a mistake? I wonder, as they ask you the question, do you regret? I wonder if they regret that they didn't bring that out. No. Why? Because it was an allegation that is meritless to the point of demagoguery. You are, I don't mean this in any way, because if anybody called me average, I would be upset, but you are a mainstream judge. Your sentencing, I've looked at the data, falls in the mainstream on everything from child sexual assault to all the other issues that people are trying to bring up. Some of these things that are being cast at you, that you called George Bush a war criminal, come on, that is painful. Especially because, as you said, the brief change, these are names that you have to put in. And we're talking about a real issue that goes to the core of our values, torture. Barack Obama was named once Bush left office. There is an absurdity to this that is, it is almost comical if it was not so dangerous. Because the next time a judge comes before us on the right or the left that has a body of work like you do, gosh, one of the some performance artists on our side could pull out one of the cases where they were below the sentencing guideline, say, for example, it was on something like as horrific as rape that we all agree is horrific, and they could suddenly put themselves as the defense. How dare we put someone who's soft on crime? Well, are you soft on crime? God bless America. I got this great text. I've become really good friends with the folks at the FOP from my negotiations, and this was my favorite text. You all got to get this. I think my brother Kennedy might get a kick out of this. He goes, things that are uncountable, stars in the sky, grains of sand on the beach, and the number of times Democrats will mention that the FOP endorsed Judge Jackson in this hearing. But let me mention it again. Just in case my people say you're rough on crime folks really want to try to make that stick. You were endorsed by the largest organization of rank and file police officers. You were endorsed by the bosses, the largest organization of chiefs of police. And you were endorsed by Noble, who I hope people find out more about that organization. You got uncles that are officers. You got a brother, not just an officer, who went to serve after 9/11. Your family's not soft on terrorism. He went out there to capture and kill and defend this country from terrorists. I actually sitting back here and finding this astonishing, but then I do my homework. I love that my colleague brought up Constance Baker Motley. You know, when she was getting to the floor of the Senate, they were trying to stop her with outrageous accusations. You know what the accusation was back then? She was a communist. Dragging up stories, trying to throw anything that they might stick. But this is what you and I know. Any one of us senators could yell as loud as we want that Venus can't return a serve. We could yell as loud as we want that Beyonce can't sing. We could yell as much as we want that astronaut Mae Jemison didn't go all that high. But you know what? They got nothing to prove. As it says in the Bible, let the work I've done speak for me. Well, you have spoken. You started speaking as a little girl, watching that man right there try to raise a family and study law while your mama supported everybody. You spoke in high school when you started distinguishing yourself. And you know what you said when they told you you couldn't go to Harvard? Watch me. I went to law school. I didn't serve on the law review. You did. I didn't clerk at every level of the federal court. You clerked for a Supreme Court justice, one widely respected on both sides, which really shaped you. You left there and you went to private practice, and you know what you found? This is what you told me. That you had those tough choices that working moms have to make, the demands of a private law firm, raising your kids. It just didn't add up. You went before this Senate 3 times in a bipartisan manner. God bless America. We don't do that much stuff bipartisan around here. You went to become a public defender because you wanted to understand all aspects of the law. Who does that? We live in a society that's very materialistic sometimes, very, very consumeristic. You went into, do people become public defenders for the money? No. Your family and you speak to service, service, service. And I'm telling you right now, I'm not letting anybody in the Senate steal my joy. I told you this at the beginning. I'm embarrassed. It happened earlier today. I just look at you and I start getting full of emotion. I'm jogging this morning, and I'm at the end of the block I live on. And I get terrified because I put my music on loud when I'm jogging, trying to block out the noise of the heart attack I'm having. And this woman comes up on me, practically tackles me, an African-American woman. And the look on her eye, she just wanted to touch me because I'm sitting so close to you, and tell me what it meant to her to watch you sitting where you're sitting. And you did not get there because of some left-wing agenda. You didn't get here because of some dark money groups. You got here how every black woman in America who's gotten anywhere has done, by being like Ginger Rogers said, I did everything Fred Astaire did, but backwards in heels. And so I'm just sitting here saying, nobody's stealing my joy. Nobody's going to make me angry, especially not people that are called in a conservative magazine demagogic for what they're bringing up that just doesn't hold water. I'm not going to let my joy be stolen because I know you and we appreciate something that we get that a lot of my colleagues don't. I know Tim Scott does. When I first came to this place, I was the 4th black person ever popularly elected to the United States Senate. And I still remember a lot of mixed people, white folks, black folks work here, but at night when people are in line to come in to clean this place, the percentage of minorities shift a lot. And so I'm walking here, first week I'm here, and somebody who's been here for decades doing the urgent work of the Senate, but it's the unglamorous work that goes on no matter who's in offices. The guy comes up to me, all he wants to say, I can tell, is, I'm so happy you're here. But he comes up and he can't get the words out. And this man, my elder, starts crying. And I just hugged him. And he just kept telling me, it is so good to see you here. It's so good to see you here. Thank you, thank you, thank you. I love my brother, Tim Scott. We can write a dissertation on our disagreements. He gave the best speech on race. I wish I could have given good of a speech. But talking to the challenges and indignities that are still faced. And you're here. I was in the White House with my Democratic colleagues, and I'm in my joy. I can't help it. and the president's asking our advice, who should we nominate and whatever. And I look at Kamala and we have a knowing glance, which we've had for years when she and I used to sit on this end of this committee at times. And then I try to get out to the president what it means. What it means. And I want to tell you, when I look at you, this is why I get emotional. I'm sorry, you're a person that is so much more than your race and gender. You're a Christian, you're a mom, you're an intellect, you love books, but for me, I'm sorry, it's hard for me not to look at you and not see my mom, not to see my cousins, one of them who had to come here and sit behind you. She had to have your back. I see my ancestors and yours. Nobody's going to steal the joy of that woman in the street or the calls that I'm getting or the texts. Nobody's going to steal that joy. You have earned this spot. You are worthy. You are a great American. Your hero is Constance Baker Motley. Mine, she has sat on my desk for my offices that I've held. She's my icon of America. Her name is Harriet Tubman. There is a love in this country that is extraordinary. You admitted it about your parents. They loved this nation, even though there were laws preventing them from getting together. When they were loving, there were laws in this country that would have prevented you from marrying your husband. It wasn't that long ago, it was last generation. But they didn't stop loving this country, even though this country didn't love them back. And what were the words of your heroes and mine? What did Constance Baker Motley do? Did she, this country that she saw insult and injuries, when she came out of law school, law firms wouldn't even hire her because she was a woman. Did she become bitter? Did she try to create a revolution? No, she used the very constitution of this nation. She loved it so much, she wanted America to be America. As Langston Hughes wrote, "Oh, let America be America again." The land that never has been yet, but yet must be the land where everyone is free. Oh, yes, I say it plain, America never was America to me, but I swear this oath, America will be. That is the story of how you got to this desk, you and I and everyone here, generations of folk who came here and said, America, I'm Irish. You may say, no, Irish or dogs need to fly, but I'm going to show this country that I can be free here. I can make this country love me as much as I love it. Chinese Americans first forced into near slave labor, building our railroads, connecting our country, saw the ugliest of America, but they were going to build their home here and say, America, you may not love me yet, but I'm going to make this nation live up to its promise and hope. LGBTQ Americans, from Stonewall women to Seneca, hidden figures who didn't even get their play until some Hollywood movie finally talked about them and how they were critical for us defying gravity. All of these people loved America. And so you faced insults here that were shocking to me. Well, actually not shocking. But you are here because of that kind of love. And nobody's taken this away from me. So you got 5 more folk to go through. 5 more of us. And then you can sit back and let us have all the debates. And I'm going to tell you, it's going to be a well-charted Senate floor because it's not going to stop. They're going to accuse you of this and that. Heck, in honor of your person who shares your birthday, you might be called a communist. But don't worry, my sister. Don't worry. God has got you. And how do I know that? Because you're here. And I know what it's taken for you to sit in that seat. Harriet Tubman is one of my heroes because the more I read about this person, the more, she was viciously beaten. For her whole life, she used to fall into spells, cracked skull. She faced starvation, chased by dogs. And when she got to freedom, what did she do? Did she rest? No, she went back. Again and again and again. The sky was full of stars. But she found one that was a harbinger of hope for better days, not just for her and those people that were enslaved, but a harbinger of hope for this country. And she never gave up on America. She fought led troops in the Civil War. She was involved in the suffrage movement. And as I came back from my run, after being near assaulted by someone on the street, I thought about her and how she looked up. She kept looking up. No matter what they did to her, she never stopped looking up. And that star, it was a harbinger of hope. Today, you're my star. You are my harbinger of hope. This country is getting better and better and better. And when that final vote happens and you ascend onto the highest court in the land, I'm going to rejoice. And I'm going to tell you right now, the greatest country in the world, the United States of America, will be better because of you. Thank you.
Thank you, Senator Booker. We're going to take a 10-minute break.
Thank you.
And come back and have the last 5 senators ask their questions.
Everything is
Committee will resume with Senator Kennedy of Louisiana.
Thank you, Mr. Chairman. Judge, I want to continue where we left off yesterday and try to get, if I can, get to the essence of this tension between judicial power and judicial restraint. You have testified, and stop me if I get this wrong, that judges should stay in their lane. And I think it's fair to say that one of your definitions of staying in your lane is that judges don't make policy. Am I right so far?
Yes, that is correct, Senator.
Then how do you explain or help me understand the following? We have a judicially created doctrine with no textual basis either in the Constitution or a statute called substantive due process. And through substantive due process, our federal courts, let's just narrow it down, the United States Supreme Court has given itself the authority to read into the Constitution unenumerated, unmentioned rights. Not read the Constitution and say, well, there it is, freedom of speech. But these are unmentioned, unenumerated. Isn't that making policy?
Senator, the Supreme Court interprets provisions of the Constitution, and there are provisions of the Constitution that require interpretation because they don't just on the text in every circumstance answer the question before the court. So due process, what does that mean? And the Supreme Court has, the words due process do appear in the text of the Constitution, and the question is what is covered by that provision? The Supreme Court, oh, sorry.
I was just going to say, but when they do it, aren't they making policy?
Well, Senator, the role of the judiciary is to interpret the law. To the extent that somebody argues to the court that there's been a violation of the due process clause of the Constitution, it is within the role of the court to determine what that means, whether the person is correct that what happened with respect to their case violated the due process clause. And so there's an interpretive function that is a part of the judicial function.
Here, let me see if I can put a finer point on this. It's not the right so much. It's how the right is created. That's why I asked you yesterday whether you think that these unenumerated, unmentioned rights ought to be decided by the people through their elected representatives versus the federal judiciary. Let's take two rights that I talked about yesterday, the right to assisted suicide, the right of a transgender woman to participate in women's sports. I can see how, I'm not predicting that it will, but I could see how the court, either through the due process clause or the Ninth Amendment, could find those rights in the Constitution. As we talked about yesterday, the Supreme Court looks to me like they've adopted the policy of there is no test for a fundamental right. There are several tests. And in Obergefell, Justice Kennedy cited with approval Justice Harlan's dissent in Poe v. Ullman, which says there's no test. We go case by case. And but I know there are tests, like I'll get the language here somewhere. I've got it. I don't want to look it up, but implicit in the concept of ordered liberty, and you've talked about that. Here's a new one that Justice Kennedy talked about in Obergefell. He said, inherent in the concept of individual autonomy. Well, I can see how if the court with 5 votes wanted to say, even though the right to assisted suicide or the right of a transgender woman to participate in women's sports, I can see how somebody, you're smart, you could write an opinion and say that's inherent in the concept of individual autonomy. And maybe, again, it's not the right, it's who's supposed to decide. And that's where the judicial restraint comes in. I mean, don't you think that the values of ordinary Americans and their ability to decide these issues are just as good as those of 5 members of the Supreme Court?
Thank you, Senator. There are policy determinations that are made by vote, and absolutely in the democratic process, people get to decide things. The question and the difficulty is when you have a constitutional scheme of government and you have a constitution that does protect certain rights, and it does so in a circumstance in which those rights, whatever they are, enumerated or not, are might be things that the people have disagreed with. That's the tension. That although we have democracy as we do, and people vote and should absolutely, we also have a constitution that protects certain rights against the sort of majority will about those things.
But the rub, of course, is, I agree with everything you said, but the rub is these are unenumerated rights.
Yes.
They're read into the Constitution.
Yes.
And what troubles me, I'm not saying I disagree with all the rights that the Supreme Court has created, but I don't think we talk honestly enough about how those rights should be adjudicated. For example, I'm not asking you to comment on this. I think you already have. But when President Biden announced your appointment, or at least shortly before, he talked about, I want a judge that's going to read new rights into the Constitution through the 9th Amendment. And I'm sure some Americans are saying that's a good thing, but you got a lot of Americans going, hey, wait a minute. Supreme Court isn't elected. A couple years ago, Chief of Staff Ron Klain wrote an opinion piece, and he said he hopes, and I'm going to quote, that, quote, I hope the Supreme Court will intervene whenever the nation's conscience and laws need a jolt in a progressive direction. That's policy making. Do you agree with that statement?
Do I agree with the statement that that's policy making, or
No, did you
I'm
agree
sorry,
with what the chief said?
Senator? That's a political statement made by someone in the executive branch.
Okay. I'm not going to push you on that. I get it. It's not a good time to make the chief of staff mad, is it? Well, I hope you'll keep this in mind, Judge, if you're confirmed. I mean, this is what judicial restraint is all about, and I think part of the division in our country. America's a big, wide open, diverse, sometimes dysfunctional, but sometimes imperfect, but basically good country. But we have different values. That's part of our diversity. And I think our country works because of our system of federalism. The values in Louisiana may be different from the values in Maine. And if you don't like what's going on in Maine and you like what's going on in Louisiana, you can move. But as our federal government has gotten bigger and bigger and bigger and bigger, what is developed, at least here in Washington, is this managerial elite. And when I say the managerial elite, I mean the entrenched politicians. I guess I shouldn't say entrenched because that's pejorative, but we do have a lot of politicians that have been here a long time. They're members of the media that are part of the managerial elite. They're members of the administrative state. They're academics that are part of it. There are a lot of corporate phonies that are part of it. And many people in this cabal think they are smarter and more virtuous than the American people. And that they ought to set forth how people should live their lives. People should shut up and just do what they're told. And if they behave, maybe the managerial elite will let them eat meat occasionally. And I think that's part of the division in our country. And I think to some extent, the Supreme Court, I don't want to say contributes to it, but it needs to be mindful of this. I'll give you another example. And this case bothers me. I want you to explain it. I think Lindsay talked to you about it, but I don't know that. I want to hear you explain it. It's Make the Road New York versus McClellan. You remember that one?
I do.
Yeah. Here's the way I read it. Congress, we, in a rare moment of consensus, gave DHS the sole and unreviewable, those are not my words, they're in the statute, the sole and unreviewable right to determine when illegal immigrants should be removed on an expedited basis. The Department of Health of Homeland Security, taking this statute, decided to use its sole and unreviewable authority or discretion to state that we're going to have expedited removal of all illegal immigrants who've been in the U.S. less than 2 years. And you said no. And not only that, but you issued a universal injunction. And I don't understand why. You talked about judicial activism, and I don't see how clearer Congress could have been. Now, the D.C. Circuit reversed you, but I want to hear your reasons for issuing that nationwide injunction.
Thank you, Senator, for allowing me to address that decision in that case. The statute at issue gave discretion to DHS to determine the amount of time that a person needed to have been in the country between 0 and 24 months in order to be subject to expedited removal, as opposed to the normal removal process in the immigration system. The statute said that DHS had sole discretion, meaning no, I interpreted, meaning no other agency was to have the authority to make that determination. And the statute said that DHS's determination in that regard was unreviewable, meaning it was final. Once this is how I'm interpreting. Meaning that once the decision was made, it was over. Nobody else gets to review. The court doesn't get to say, no, you're wrong if you pick 12 months, for example, or 16 months or 24 months, as they did in this case. The statute did not speak to whether Congress intended, with that grant of very broad discretion, to exclude another statute that Congress has passed that directs agencies, when Congress gives them discretion, the other statute, the APA, directs agencies as to how they go about making decisions that Congress has given them the authority to make. The APA is a procedural statute. It says to agencies, when Congress gives you discretion to make a determination, you have to do so in a way that's not arbitrary and capricious. You have to use your expertise.
Right.
In certain kinds of decisions, you have to use notice and comment in order to get information. It's procedural. The claim that was being made in this case, as I read it and understood it, was not that the agency couldn't pick 24 months, because obviously Congress had said in the statute you can pick between 0 and 24 months. The claim that was being made is that the agency picked 24 months arbitrarily in violation of Congress's direction about how you go about
The
exercise.
APA was violated?
Yes, the claim was an APA violation. So no one was saying that the statute was violated in the sense that the agency did something that it couldn't have done per the statute, picking 24 months. They said the APA was violated because, this is the claim that they were making,
Sure.
because the agency did no analysis, the agency did no expertise, the agency did not evaluate, okay, if you've been here 6 months, these are the kinds of ties that you have. If you've been here 18 months, right?
Got it.
The agency didn't do anything. Essentially, according to the claimants, the agency heard the president say, we're going to now do 24 months when everybody else, all of the other administrations up to this point.
Because I've only got 2.
Yes, I'm sorry. All right.
So what I hear you saying is, tell me if I'm wrong.
Yes.
They didn't follow the APA, in your opinion, which you have to do even though Congress passed the statute? Is that
Well, no, because two things. One is the APA under DC, longstanding DC Circuit case law is presumptively applicable to every situation in which an agency is exercising its discretion. So that's the first thing. It's always there as a background rule. So the DC Circuit has said Congress has to be pretty clear when it decides to exclude the APA, when it's saying, I'm giving you discretion, but you can do this arbitrarily, you can do it however you want. And in other places in the immigration statute that sets up expedited removal, Congress says, we are excluding the APA. We're telling you that with respect to this kind of discretion, the APA doesn't apply.
I got you.
So here I had these two statutes, and there are canons of statutory interpretation that says that you should try to give effect to all of the will of Congress. You should try to read statutes so that they go together in a way if you have these two directives. And there's also DC Circuit case law.
Judge, I got to stop you
All right.
because I got it.
And let me just say, I agree that the DC Circuit reversed me. They disagreed with my interpretation, and that's the way that our system works.
Let me ask this last question. This is a question about based on your experience. Can we agree that if, I want to emphasize if, cocaine is cocaine, that crack cocaine is equal in its danger to powdered cocaine? You with me?
I think so.
One is not more dangerous than the other. If that's true, then the sentencing rules ought to be the same. Okay?
It's a policy matter for Congress. You could make them differently if you wanted to.
This is what I want to ask you.
Yeah.
Based on your experience, you've been
Yeah.
on the bench a decade.
Yes.
Is crack cocaine more dangerous than powder or less or the same?
Senator, that's a policy determination. That's what policymakers do. They look at the evidence related to these things and they decide what's more dangerous.
But what have you seen?
What should I have seen evidence through the Sentencing Commission that the two compositions are chemically similar, so similar as to be indistinguishable. And the commission, for very many years, as a policymaking body, indicated its view that they should be equivalent and lobbied Congress concerning that. And Congress made a determination about, in the policy realm, making it 18-1 instead of 100-1, which is what it had previously been.
Okay. Thanks, Mr. Chairman.
Thank you, Senator Kennedy, and now Senator Padilla.
Mr. Chairman, before I begin, I know you're being very mindful of the clock, so I just want to say I have two initial, more substantive questions, and then I think two very brief questions, but are very important. So I'll get right to it. Judge Jackson, I am so glad that you take some pride in sharing your family's story, as you should. I know I take pride in sharing mine. My colleagues have heard it, but I never get tired of reminding folks that I am the proud son of immigrants. My parents came to the United States from Mexico decades ago, and through their hard work and determination, they raised three of us. My sister, my brother, and I, we all attended and graduated from college, and we've all found successful careers in public service. Now, it's a story that is shared by hardworking immigrant families across the country. And over the course of generations, families who work diligently each day to create a better life and to contribute to the country. Whether it's as farm workers, short order cooks, celebrity chefs, software engineers, or tech CEOs, as school custodians, teachers, principals, whether they're documented or undocumented, people who migrate to this country seeking asylum, seeking refuge, or a shot at the American dream, all deserve to be treated with dignity and humanity. Now, unfortunately, our laws and our courts don't always do that. Beyond our often cruel and counterproductive choices that we've made over the years when it comes to immigration policy, the language that we use to speak about immigrants can often have dehumanizing effects. For example, in the Immigration and Nationality Act, it's replete with references to quote-unquote aliens. And court opinions written by federal judges across the country can be found referring to undocumented persons as, quote, illegal aliens. Now, I know NASA has put a man on the moon, and there are billionaires increasingly exploring space. But let's be clear, no person is an alien, and no human being can be illegal. So with that context, I read your immigration-related decisions on the district court with great interest. Now, beyond the substance of your opinions, what stood out to me is that you seem to have tried to avoid making the same choice as many of your predecessors and many of your colleagues. When not quoting statutes or precedent, your opinions appear not to refer to immigrants as alien or illegal. Instead, use terms such as undocumented and non-citizen. I hope that was a conscious choice. The language we use and the language our courts use to describe people, whether immigrants, the formerly incarcerated, individuals who identify as LGBTQ, or other historically marginalized people, really matters a great deal. Our language matters. It's exactly for that reason that 6 years ago, Congress passed a bill to remove derogatory and offensive references to Black Americans, Asian Americans, and Native Americans from the U.S. Code. And it's why last year President Biden ordered the Customs and Border Protection Agency and ICE to stop referring to migrants as illegal immigrants. With all that said, Judge Jackson, do you agree that the language we use to describe one another and the language used by the bench matters?
Thank you, Senator. As I mentioned earlier in this hearing, judges are the only branch of government who are required to write our opinions, to explain our decisions. And I have long believed in that capacity that our clarity and language matters. We're explaining the law to people, and people read and understand what the law is, what the rule of law is in this country through the opinions of judges. So they do matter, language.
Thank you. Now I want to discuss with you an issue of law and technology, an issue previously raised by Senator Ossoff earlier today, and I'm excited to talk to you about this topic. Just as an aside, any day that an MIT engineer gets to question a Harvard lawyer, it's a good day. So thank you for indulging. But as you know, the Supreme Court only hears a tiny fraction of all federal appeals. That means that the cases that get to the Supreme Court are typically either new questions of law or very difficult questions of law. And I think the intersection of law and technology is one where many cases are both new and difficult. Over the course of human history, innovation has constantly disrupted our culture and our norms. And for the most part with good intentions, but societal benefits have not always been the result of innovation. Innovations have challenged us to respond with new means of safeguarding basic rights, whether in the context of privacy, security, competition, employment, just to name a few. And I appreciate that the speed of innovation will always challenge our ability to keep the law up to date with new technologies and their impact. I've grappled with this question as a city council member, as a state senator, as a secretary of state, and now as a United States senator. But clearly, it's also a challenge for the courts, which often have to decide cases during that period between technological progress and the enactment of new laws that seek to account for that progress. Now, new technology alone has given rise to a number of fundamental questions of law, as you mentioned yesterday and earlier, including how the Fourth Amendment applies to new contexts that no founder could have ever contemplated. And likewise, the court has to grapple with questions like how copyright law applies to computer code. And in the coming years, new technologies will present new questions, not just in the context of the Fourth Amendment, but in areas of communications, energy, transportation, healthcare, and many others. So if you can take just a minute, Judge, to discuss the challenges that courts at every level face in addressing cases involving new and emerging technologies, and how you, as a Supreme Court justice, would begin to prepare for these types of cases.
Thank you, Senator. The court does get cases that involve disputes that touch on technological innovation, whether it is something like copyright kind of case, or a patent kind of case, or the Fourth Amendment search and seizure. New technologies do intersect with what the law says in the Constitution and in statutes. And at least as far as statutes are concerned, it's certainly much easier for judges who are doing their duty to interpret the law if Congress makes changes that update the statutes to track the modern innovations. What happens with constitutional interpretation is similar to what I described earlier about cases in which the court analogizes back to the time of the founding concerning the principles in something like search and seizure, what qualified as a search that violated the Constitution when those words were written, and then determines whether that same kind of violation is at issue with respect to the technology today. And the court has done that with respect to searches regarding cell phones, police access to GPS data, tracking technology that is put on vehicles, because these disputes do come up. And so, so I'll take this opportunity to encourage Congress to help us by ensuring that new technologies are addressed in statutes that we interpret.
You're absolutely right. Both judges and members of Congress are never done doing more homework and learning, hopefully. Judge, on Monday, which at this point feels like so long ago, I suggested in my opening statement that by the end of these hearings, America would know just how qualified you are to serve on the Supreme Court. And over the course of this hearing, I think the American people have seen that and have gotten to know you as a person. They have heard your family's journey and everything that your nomination represents. Now, I also said on Monday that your qualifications bear repeating over and over again. And so, Judge, with your help, I'd like to remind the committee and the American people once again just some of your incredible credentials. Yes or no? After law school, did you serve as a law clerk for a district court judge, a court of appeals judge, and a Supreme Court justice?
I did, Senator.
Yes or no? Did you practice law for more than 10 years before becoming a judge?
Yes, Senator.
And did that include time in private practice and time as a federal public defender?
It did.
How many years have you served as a federal district court judge?
I served as a federal district court judge for, I believe, 8.5 years.
And circuit since then?
Circuit since last June.
And as a district court judge, approximately how many opinions did you write? I think we've covered this before.
As a district court judge, I believe I wrote somewhere in the neighborhood of 560.
With a very low rate of having been reversed, if I've done my homework correctly. Look, I can go on, and don't worry, Mr. Chairman, I won't. But Judge Jackson, for 2 days, here's what I've seen. I've seen a number of my colleagues trying to engage with you in good faith on questions about the law, and you've answered them fully, fairly, and thoughtfully in every instance. You've shown yourself to have the keen intellect and legal acumen to serve on the Supreme Court. Now, you've also sat here and politely listened as some of my colleagues have attempted to disparage your judgment and character based on allegations that even, as Senator Booker pointed out, conservative commentators have called meritless to the point of demagoguery. And through that, you've shown clearly that you have the temperament to serve on the Supreme Court. Now, this confirmation hearing has been a reminder, and in some ways, a new Exhibit A, that for people of color, particularly those who have the audacity to try to be the first, often have to work twice as hard to get half the respect. Judge Jackson, I offer that with your talent and exemplary qualifications on full display. If my colleagues truly believe in maintaining the legitimacy of the Supreme Court, if they really care about Americans' faith in the judicial system, they will see that even if they may disagree with you on a particular area of the law, that you're exactly the type of judge that should serve on the Supreme Court. You're exactly the type of judge that should receive bipartisan support, not just from this committee, but from the full Senate. And if any senator doesn't, then I hope they'll think long and hard about what it says to the country about the politicization of the Supreme Court. That if someone is eminently qualified as Judge Jackson in all the ways that we've been discussing, cannot receive bipartisan support. Judge, and there's just a couple minutes left, and I'd like to ask you just one last question. Last Friday, in my preparation for these hearings, I took the opportunity to spend some time with a group of students at South San Francisco High School. I went there to speak with them about this historic Supreme Court nomination and to speak with them about you. We had a great conversation about how the court's decisions affect the everyday lives of Americans and about the past and the future of the Supreme Court. But as I was speaking with the students, I couldn't help but be reminded of my own high school experience when one of my teachers discouraged me from applying to MIT because they didn't want me to be disappointed. I turned that discouragement into motivation. Judge Jackson, I know that you too have been doubted on your way to the seat that you find yourself in today. Even over the last 3 days of this hearing, your experience and qualifications have been called into question by some, despite your clear, lengthy record of talent, achievement, and accomplishment. So I want to end my time today by asking you this question. On behalf of the young people I visited with last Friday in South San Francisco, and for the many others across the country who are watching this confirmation hearing today, what would you say, Judge Jackson, to all those young Americans, the most diverse generation in our nation's history? What do you say to some of them who may doubt that they can one day achieve the same great heights that you have?
Thank you, Senator. That was very moving. And I appreciate the opportunity to speak to young people. I appreciate it very much. I do it a lot for the reasons that you have articulated. I hope to inspire people to try to follow this path because I love this country, because I love the law, because I think it is important that we all invest in our future. And the young people are the future. And so I want them to know that they can do and be anything. And I'll just say that I will tell them what an anonymous person said to me once. I was walking through Harvard Yard my freshman year. As I mentioned, I went to public school, and I didn't know anything about Harvard until my debate coach took me there to enter a speech competition, and I thought, this is a great university. It was basically one of the only ones I'd seen, and I said, maybe I'll apply when I'm a senior. But I get there, and whoa, so different. I'm from Miami, Florida. Boston is very cold. It was rough. It was different from anything I'd known. There were lots of students there who were prep school kids like my husband, who knew all about Harvard, and that was not me. And I think the first semester I was really homesick. I was really questioning, do I belong here? Can I make it in this environment? And I was walking through the yard in the evening, and a Black woman I did not know was passing me on the sidewalk, and she looked at me, and I guess she knew how I was feeling, and she leaned over as we crossed and said, "Persevere." I would tell them to persevere.
Thank you, Judge Jackson. You don't have to hope. I'll tell you right now, you do inspire. You are an inspiration.
Thank
And I will associate myself with the closing words of my colleague and my brother, Senator Booker, that I too refuse to let anyone steal my joy. Thank you, Mr. Chair.
Thank you, Senator Padilla. Senator Tillis.
Thank you, Mr. Chair. Judge Jackson, as Senator Booker was providing his closing comments, I could only think, and they were very powerful, that if you liked his, how much you're going to like mine on the subject of intellectual property. But before I do that, I know you've been spending a lot of time here. Do you have much experience in matters of copyright protection, patent protection?
Senator, I mentioned earlier that I did a trademark case.
Yeah.
Not
By
that.
the way, I looked up the menu. It looks
Did
like
you?
a really good menu.
I think it's a good restaurant. They had a lot of evidence to that effect.
I haven't done a lot of food or restaurant trademark work, but when I came to Judiciary, fortunately, the former chair and the current chair indulged us in reinstituting the Intellectual Property Subcommittee. And I love that committee because you really have to work hard to be partisan in it. And in fact, it's not partisan. I worked very well with, as the chair, with Senator Coons, and done very well with Senator Leahy and Senator Rono, and working together on things that I think are really important. Because I think one of the things that make our country great is the Founding Fathers got it right on understanding the value of intellectual property and how it could catapult us into the innovation powerhouse that we are today. So I may ask you a few questions about it, but I'm not going to dig too deeply. I do want to go back to maybe getting a suggestion from you. I thought, I told you, I don't even pretend to be an attorney, but I am about 30 years into technology. As a matter of fact, I spent 2 years in Boston at Wang Laboratories, and it was no coincidence, having been born and raised in Florida, that I moved one September because I couldn't bear another winter. But I've been in the technical field. I was working on IP, or Internet Protocol, before anybody knew what Internet Protocol was back in the early 90s. And I do think that we should go away and understand the threat. If you've seen the multiple of illicit activities, and for the purposes of this discussion, child pornography now, imagine what it's going to be like 5 years from now. I was talking with someone in the hallway. They're taking a playbook from drug kingpins, the creators, and the aggregators and the distributors are using technology, I think in some cases, to reach out to people and incent them to go to these websites, to infect their computers, to download thousands potentially from a single click. I think that we have to examine these criminal enterprises and put law enforcement resources into cutting the heads off of these people, figuratively speaking. And one of the ways you do that is to provide, I think, more ways to go about prosecute, more technology that we need to cut down the supply. But we still have to deal with the demand. And that's another area where these criminal organizations and others are taking advantage. And, you know, today, if you think about technology 10 years ago, it was a little odd, at least 15 years ago, to see a child. I've got two granddaughters. One is 4 years old, one is 2 years old. They're technologically savvy. As a matter of fact, I love talking to them on the phone, but even my 2-year-old knows how to deal with the filters to make me look like I've got rabbit ears and everything. They're technologically savvy. There's a real danger there that these horrible people, and I genuinely believe that you think they're horrible people, are going, they're going to infect and destroy a lot of lives. And so I don't know, is it with the Sentencing Commission? And incidentally, this is a toxic subject in Congress, because if you start talking about better understanding those, most people are going to run away from it. But we do it at the expense of destroying a lot of victims' lives. So I don't, unless you have ideas off the top of your head, I'm trying to get an idea of how we can make people understand. Maybe we could even have a discussion to say that the penalties today are the floor to begin the discussion, just to simply eliminate people from making this so toxic that we don't better understand it and get ahead of it. But how can we even start having an intelligent discussion and a productive discussion where Congress is clearly going to need to act to do what I think everybody in this room wants to do, is just erase it from the planet of the earth, or at least make a lot of progress, because quite honestly, it has exponentially grown, and there are exponentially more victims today than there were even 10 years ago. Any ideas?
Thank you, Senator. I actually don't. I haven't been working on or looking at or dealing with sentencing policy for a long time now. In my work as a judge, we're looking at individual cases, not systems or crime organizations and policies related to them.
Yeah. Well, I think it's something that we should take seriously, and after we cool the temperatures and have people have legitimate concerns about some of the rulings, I think that we have to clear up some of the complexity and recognize that Congress is a part of the solution. Okay, now on the weighty subject of intellectual property, are you familiar with copyright preemption under Section 301A?
No, I haven't worked with that.
Okay. I wouldn't have expected you to necessarily, but, and I won't get into patent questions. We've got a lot of work that I think ultimately is going to require us getting rid of the shambles of jurisprudence that we have. It's a very complicated field. We've got a lot of mixed signals and current jurisprudence, and my committee's working on that. So it may be something that ultimately works its way up to you all if you're confirmed. But I'm not going to take a lot of time, particularly because the hour is late and I intend to yield back some of my time. I do want to go back because I felt like this morning when I went through some of my comments, I mentioned law enforcement. I talked about a couple of your decisions that gave me pause, mainly, excuse me, because, you know, law enforcement's under attack. Law enforcement needs to be held to a high standard. I've been involved in this for nearly 22 years, making sure that when I was the town councilman, that we did something audacious and spend a lot of money in getting our law enforcement officers in a small town of only 20,000 people, CALEA certified. That's a national certification to make sure that they understand how to de-escalate get engaged in the community and reduce crime, and it worked. But now there are some people that think it's fashionable to attack the police and to defund the police. And quite honestly, there's increasing data that suggests the communities that are loudest about that are becoming the least safe. So I want to ask, you mentioned several times, I think yesterday and more today, about your methodology. So is the United States versus Jenkins fresh in your mind, or roughly fresh in your mind? Criminal pleaded guilty to assaulting a law officer. It was his third conviction in assaulting a law enforcement officer. The government recommended 30 months. The defense recommended 21 months, and you decided to go with an 18-month sentence. So I was trying to, do you recall?
I don't recall. I would want to look at the records and see the probation office's recommendation as well.
Okay. And that, again, is something I wouldn't have access to. So I'm just trying to figure out what the mitigating circumstances were. And there were other ones. And unless you immediately recall it, I'm not going to ask you to go into details. The other one was United States versus Weeks. Similar situation. There was a 24-month request from the government for the conviction on assaulting an officer, and you gave them 12 months. And does that ring a bell, United States versus Weeks?
I think Weeks had a number of different appearances, and there were different aspects to his case, but I'd have to look at the whole file to recall.
That I just feel like again, because I know that you've rendered some 100 sentences over a period of time. I wouldn't expect you, but it is an area that we'll submit it as a question for the record, so that maybe you can refresh your memory and try to get back on that, because it's something that I, for one, think that we need to place a priority on. We've got so many law enforcement agencies across the country now, that we're having a hard time recruiting people and having a hard time retaining people. A lot of people are retiring. And, I know not every police officer is an angel. I was talking with somebody in my office who was talking about her brother. She had a lot of confidence in him. She was here to talk to me about police reforms. And I actually believe that the vast majority of police officers, like your brother and your family members, were good people. And a part of what we have to do is just make sure that when we have these assaults, which are increasing, that we have just punishment, because we need to do that for the protection not only of the law enforcement officers, but the communities they serve. I'm going to yield back time, because I know we've got two other people talking. And, I thought you've done a great job over the last 2 days. I've tried to be here. I had an emergency and had to leave for about an hour and a half, but I tried to be here for a business emergency. But I thought that you presented yourself well, and there was a lot of pressure. That demonstrates a certain temperament or poise. I can't imagine what's going on inside your head, but at least overtly, you did very well, and you should be proud of that. It's not an easy thing. It's very easy up here to feel comfortable, right? Because there's 22 of us, and it's not like you can really come at us. So you have an arm tied behind your back, and I'm sure that there were a number of things you'd like to say, but time didn't allow. But, I just want to commend you, your family, your daughter, who has been glowing every time you talk, and I appreciate your service. Thank you. I yield back, Mr. Chair.
Thanks, Senator
Thank you,
Tillis.
Senator.
Senator Ossoff, you started the day for us.
Judge, good evening. We've come full circle to the end of the dais. Likewise, I don't intend to use all of my time. I do want to echo the sentiments expressed by Senator Tillis. You have conducted these hearings with extraordinary poise, strength, grace under pressure. You've had a lot of poison thrown at you, and you've responded with substance and truth and it's shone through, not just in this room, but across the country and around the world. So I have two substantive questions regarding the First Amendment. One question, as I noted, that I wanted to address regarding war powers, and then I'll be yielding the remainder of my time to the chair and on to Senator Blackburn to close. We discussed earlier this morning, Judge, the constituent elements of the First Amendment with respect to speech, expression, and assembly. I just briefly want to touch on the free exercise of religion. My great-grandparents came to this country fleeing anti-Semitism in Eastern Europe. Many American stories, including many of the very first American stories, involve flight from religious persecution. Just briefly would ask you to touch upon the constitutional roots and significance in our system of government of the First Amendment protection of the free exercise of religion.
Thank you, Senator. As you mentioned, free exercise of religion and the Establishment Clause, which prevents the state, the government from preferring religion over another, is foundational. It is the principle that many people originally came to this country when it was founded in order to support. It was people who fled from religious persecution and wanted to found a country in which everyone could believe what they wanted to believe and not have the government encroach on, impinge on, burden that right. And so it is a core foundational right. It's in the First Amendment, and your family story is very similar to many families who moved to this country for that reason.
Thank you, Judge Jackson. We discussed in brief earlier today the Sullivan decision, New York Times v. Sullivan, in which the court established a standard by which libel and defamation claims by public figures would be judged. And my understanding, correct me if I'm wrong, is that the standard is that false statements must be made knowingly, that the party making the false statement must know that it is false, and must make such knowingly false statements with malice. Am I correct that that's the standard in the case?
I believe it's knowingly or with reckless disregard for the truth, and that standard is termed or thought of as actual malice, yes.
Is there any generalized obligation in law that you're aware of to accurate reporting or accurate publication where there is not malice or where there is not one of the components established in the Sullivan case?
If I understand your question, I know that the standard related to the Sullivan case does pertain to public figures. And so if a public figure is not involved, there's a different standard in terms of liability for inaccurate or defamatory statements.
Thank you, Judge. And I want to note that the chairman earlier remarked upon the disruptions in the market in publishing and the dissemination of information that technology has caused in recent years. And I was just reflecting, as the chairman spoke, that at the time of the invention of the printing press, many of those who previously had centralized control of the production and dissemination of information recognized that it was disruptive and threatening and that it disrupted power dynamics, and it empowered new participants in public discourse to participate. And I just want to express to you, this is not a question, but express to you my view that it is vital that we in Congress and the judiciary relentlessly defend the principles of the First Amendment and the free expression of ideas, even as new technologies emerge which disrupt these markets and present challenging new particular circumstances to the court. A very brief question on the not lighthearted but important subject of war powers. I reviewed some of the comments that prior nominees have made when asked about questions with respect to the allocation of war powers between the legislative and executive branches. And something that I've seen in some of those transcripts has been a tendency to say, well, these are disputes between the political branches, and questions about those authorities should be resolved between the political branches. I noted in the McCann opinion that you issued, you noted in that case that one of the reasons it was appropriate for the judiciary to consider the claim made by the U.S. House in that case was that where there is a dispute between the legislative and the executive, in that case, and perhaps in many cases, the judiciary is precisely the appropriate forum for the resolution of that dispute. And so it seems to me that the court and you, should you be confirmed, may very well have to entertain cases and controversies pertaining to disputes between the legislative and the executive with respect to war powers, because there is, in my opinion, unsettled law. There's some ambiguity in statute. The Constitution allocates various authorities to the two branches. So not asking you to posit a thesis on this point, but just want to ask you how you will approach such cases. I assume applying the methodology that you have laid out for us consistently throughout these hearings, where war powers may come before the court.
Thank you, Senator. In every case, I applied the methodology that I have laid out in order to ensure that I'm ruling impartially and consistent with my judicial authority. In the part of my methodology that addresses my judicial authority, one of the things that I do, as judges do, is decide whether I have jurisdiction to hear a particular issue. The McGahn case was not a war powers case. The McGahn case, I determined in that opinion, and Judge Bates had determined in the prior opinion, raised a question of law. The question essentially was whether the subpoena that had been issued by the House had to be responded to by the person who received it, or whether that person had absolute immunity and did not have to respond. That's a question of law that courts answer all the time with respect to the enforceability of subpoenas. In the war powers realm, there may be questions of law that are appropriate for courts to decide, but there may also be political questions. And so it would depend, a political question, if there was a dispute between the legislature and the executive branch over some exercise of authority that was not governed by law, but was in the discretion of either of those branches under the Constitution, where they got to make determinations, something, say, for example, like the exercise of executive authority in war to move troops or do that kind of thing, that would not present a question of law that the court could decide. So it would depend on exactly what the court was being asked to do as to whether or not it had jurisdiction. And under my methodology, that would be the kind of thing that I would have to carefully examine in order to determine whether I could rule.
Thank you, Judge. Let me close with this comment. as I said, you have conducted yourself with extraordinary skill and grace throughout these proceedings. And it's in some ways a lonely place for you to sit there under the lights, facing questions, many of them substantive, some of them less so, many of them constructive, some of them mean-spirited and distracting. You've handled it all extraordinarily well. It's been a very long 2 days. I know you know this, but I just want to make sure you do, that throughout this process, and right now, there are millions and millions of people who are watching and cheering you on, right at this very moment, in homes across this country. There are millions and millions of people inspired by you and your example who are cheering you on. And not just that, there are people all over the world, who are watching these proceedings and seeing what is possible in America. After some years when there's been some doubt about what this country stands for. That's my opinion, not yours. But people all over the world are watching this and seeing what is possible in America, what is possible in the system of government that we have, what values this country stands for. And I thank you profoundly for the service you've rendered throughout your life and in this hearing. And with 7 minutes remaining, Mr. Chairman, I know you'll remain focused right through the end. I have no doubt that Senator Blackburn has some provocative questions for you. I yield the remainder of my time.
Thank you very much, Senator Ossoff. And Senator Blackburn,
Thank you, Mr. Chairman. And I know that Senator Ossoff is over there watching your wonderful family and taking notes because he's a new daddy. And if you have time, he'll show you pictures. But indeed, we have all enjoyed hearing about your family and your parents and how hard they worked to open doors of opportunity for you. And look at how you went through those doors and really created such a wonderful life. And I mentioned yesterday that I would hear from friends in Tennessee, and so many of them talk about they like how you have pushed those barriers aside, because a lot of them have had to do the same thing to kind of make their way into careers. And so they've appreciated that very much about you. And I'll have to tell Senator Booker, now I like the fact that he talked about Fred Astaire and Ginger Rogers. And when my daughter was in high school, I actually bought that poster, and I've probably told Senator Klobuchar this before, but I bought that poster of Fred Astaire and Ginger Rogers, and they're dancing, and it says, "I took every step he took, but in high heels and backward," just to make the point with her that she was going to have to work hard. And indeed, she accepted that challenge, and I'm really proud of her, like I know all parents are proud of their children. I do want to get to a couple of things, and we do have the vote on the board. Yesterday during our discussion, you had mentioned that you were unfamiliar with some of the statements that I had read back to you, your previous statements and writings, including the statements on child pornography and critical race theory. I was a little surprised by that because I know the White House has worked really hard to prepare you for the hearing. So I wanted to introduce documents just so that we have those in the record, Mr. Chairman. The first document is an article in which you're quoted as praising the progressive curriculum at Georgetown Day School. The quote appeared in the winter 2019-2020 edition of Georgetown Days magazine. You stated, and I quote, "Since becoming a part of the GDS community 7 years ago, I've witnessed the transformative power of a rigorous progressive education, end quote. Second document is a transcript of a 2012 hearing before the Sentencing Commission at a time when you were vice chair of the commission. The topic was child pornography offending pathways community treatment. You stated during the hearing, and I quote, "I had mistakenly assumed that child pornography offenders are pedophiles." So I went back and pulled that to show that it was a statement and not a question. So, Mr. Chairman, I ask permission to enter those.
Without objection.
Thank you, Mr. Chairman. We talked about abortion yesterday, and I want to go back to that on abortion. I had another question there. Some have argued that bills seeking to protect children who survive abortions are unconstitutional. They say that the right to an abortion includes the right to an effective abortion. So, in other words, does the constitutional right to an abortion include the right to let a baby die if that baby unintentionally survives an abortion? I'd like to know if you agree with that.
Thank you, Senator. Issues like the one that you have raised are in the court system now, and as a result, as a nominee to the Supreme Court, I'm not able to opine about the constitutionality or not of the kinds of legislation that you mentioned.
Well, one of the main factors the Supreme Court is considering is deciding whether to uphold Roe in all of this and with precedent, is if all of this is a settled issue or not. And some of those that are on this about whether it is to an abortion or an effective abortion, and if that constitutional right includes the right to terminate the life of a baby that survives that abortion. So that is an issue that will be decided before you go to the court. But I think it's important to have that discussion. I do want to go back to the issue about the child predators. And as you've heard, Senator Blumenthal and I are working on legislation. Senator Klobuchar's got some legislation that deals with technology. But I want to ask you this because of some of the questioning, and it's just a yes or a no. Do you believe child predators are misunderstood?
Senator, I don't have a context for that. I believe
Well, I'm going back to the comment on the Sentencing Commission. As you said, that not all child predators were pedophiles.
Senator, I believe that all child predators are dangerous, that the behavior that they engage in is horrible,
Okay.
that it needs to be taken seriously by the court and by Congress in setting the penalties for their behavior.
So, is it your position that child pornography offenders are not pedophiles?
Senator, I believe that the statement that you referenced was a part of a hearing before the Sentencing Commission in 2012.
Right. It was a meeting, yes.
It was a
I've got it
meeting,
right
and
here.
what the Sentencing Commission does is it
Right.
reviews evidence about various things, and I believe I was
Right. And as I said yesterday, the children that are victimized, they don't understand the difference between an offender and a pedophile or a pornographer. And I do think it's a distinction without a difference. Let me ask you about gun rights. Violent crime is rampant. We have seen that during the last year. It's making people really nervous. Pulled some stats. In 2021, 27 major U.S. cities experienced a 44% increase in homicides since 2019. Over a dozen cities set new homicide records in 21. And a lot of families no longer feel safe. So they're buying guns, they're buying ammo, and trying to make certain that they can protect themselves. And in times like this, I think we're really fortunate that the founders afforded such constitutional protection as the Second Amendment. So very quickly, walk me through what current Supreme Court precedent says about the Second Amendment.
Thank you, Senator. Current Supreme Court precedent says that under the Second Amendment, there is an individual fundamental right to keep and bear arms in the home, and the opinion focuses on those circumstances.
Okay, and so you agree it is an individual right and not only reserved to militias, because there are some that keep trying to say it's only reserved to militias. But if my memory is correct, you base this on District of Columbia versus Heller, that it is an individual
yes, ma'am,
right.
that the Supreme Court has established it's an individual right.
I wanted to get that on the record because I don't think anybody had asked you that this entire time. Here's another question. I've asked other judicial nominees that are coming to us for the district court and the appellate court, and I've really not gotten a satisfactory answer from anybody. So why is it constitutionally permissible for the right to keep and bear arms, which the Supreme Court has recognized as a fundamental right, and you agree with that? Why is it constitutionally permissible for this right to be subject to the discretionary issuance of a license by a local official?
Thank you, Senator. The Supreme Court is looking at that very issue in a case before it right now. And as a nominee for the Supreme Court, it's important that I not speak to it because the court is deciding this question. It has a pending case. I believe arguments have even occurred related to it.
So should other unenumerated rights be subject to the same type forbearance, having to get a local license? Should someone that wants an abortion have to go before a government bureaucrat? Because the Second Amendment, that right to keep and bear arms, is enumerated in the text of the Constitution. So the question would be, why should it have to have an extra burden?
I understand the question. It's one that the Supreme Court is looking at, and consistent with past practice and the need to ensure that I'm not speaking to issues that are live.
All right, then let me move on. I want to turn to some of the sentencing decisions, and particularly your decision to grant criminal defendants compassionate release. And you have an unmistakable pattern of releasing criminals with dangerous backgrounds into the community, and the COVID-19 pandemic seemed to exacerbate the trend. To name just a few examples, you use the COVID-19 pandemic as justification to release a fentanyl drug dealer, a bank robber addicted to heroin, a convict who murdered a U.S. Marshal back on the streets. And at a time when violent crimes, including homicide, are spiking all across the country, and we're facing an opioid epidemic driven in large part by the trafficking of fentanyl across our border, how can you stand by your decision that these offenders do not pose a danger to the community?
Thank you, Senator, for allowing me to answer this question. the statutes that govern judges and that allow for compassionate release are policy determinations that Congress has made to permit individuals who are in various circumstances in various stages in the system to seek release. People who are detained after their final sentencing can seek something called compassionate release. People who are detained between when they've been convicted and when they're sentenced can.
Not to cut you off, but time's going to run out. We do have, this is a question that I have been asked so much. Here's a stack. These are the ones that you sought for compassionate release. There were 1,561 that were detained in D.C. Department of Corrections. And your statement, and this was in the opinion that you issued, it was U.S. versus Wiggins. You stated, and I'm going to quote you, each and every criminal defendant in the D.C. Department of Corrections custody should be released because of the COVID-19 pandemic. And in that same opinion, you lamented the fact that you as a federal judge were limited in your ability to order the universal release of criminals back onto the streets. And I am shocked that that would have been your position, because people are they are just really concerned about crime in the streets. So do you stand by your position that it would have been the right thing to do to release all of those prisoners back onto the streets?
Senator, that was not my position. In that opinion, United States versus Wiggins, I started off by explaining that given the compassionate release system and the COVID-19 pandemic, it would seem as though that was an extraordinary and compelling circumstance. But 2 sentences later, I say, we can't release everyone. There are people who are too dangerous to release. And so even in Wiggins, I decided that he had to remain incarcerated, notwithstanding his compassionate release motion. So the point, the sentence that I have there, I did say, but I said it to lead up to my statement, which was the actual ruling, in which I said, we are not releasing everybody. We're not opening the jails.
And Judge, to lament that you were limited in your ability to order the release of all, that is what causes, that is a judgment issue. And that is what causes the concern with that. Let me go to the critical race theory issue, because you were asked yesterday about a speech you gave in April 2015 when you had stated, and I'm going to quote you again, that it melds to, when you were talking about sentencing, it melds together myriad types of law, including critical race theory. And you told Senator Cruz, I think it was, that when you made that statement, you were talking about decisions regarding sentencing policy. You said, and again, I'm going to quote, I was talking about policy determinations. None of that relates to what I do as a judge. I take that to mean that you don't make policy determinations when you're making sentencing decisions as a judge. So today, in response to a question from Senator Grassley, you said the exact opposite. You said, and I'm going to quote you again, I have at times identified various enhancements that I have disagreed with as a policy matter because the Supreme Court has said that that's the authority of a sentencing judge in our system. So given that you admitted you made policy determinations in sentencing and you stated that you consider critical race theory in sentencing policy, let me ask you again, do you consider critical race theory in your sentencing decisions as a judge?
Thank you, Senator. Critical race theory, any academic theory, is not considered in my sentencings. It never comes up in sentencing. It was not what I was talking about in the speech in 2015.
Okay. I appreciate that. I do have one intellectual property question I'm going to submit to you for writing. You've had a long day.
Thank you.
And you've been very gracious. And I think that these are tough questions, but this is part of our doing our due diligence and meeting our responsibility to the people that we represent. And they expect this of us. And as I mentioned, they've been very engaged in this. As some have said, you know, I think I would like her, I don't agree with her, or I agree on some things, but not on everything. But they want to know what you're going to do when you get on the court, because their kids and their grandkids are not going to have the opportunities that you have had unless we keep this nation free. So it demands your best, and it demands that you go to the Constitution first. In your opening statement, I pulled this, and this is where I'll end with you. You say, I've been a judge for nearly a decade now, and I take that responsibility and my duty to be independent very seriously. I decide cases from a neutral posture. I evaluate the facts, and I interpret and apply the law to the facts of the case before me without fear or favor, consistent with my judicial oath. I wish you had said consistent with the Constitution of the United States. Thank you so much, Judge, for being with us. Thank you, Mr. Chairman.
Thank you, Senator Blackburn. This concludes our rounds of questioning. And before we recess, a few observations. First, Judge Jackson, you are extraordinary. Your story is a great American story, and I think we've all benefited by getting to know you a little better during the last 2 days. You are exceptionally qualified for this position. I won't read through your resume. It's been read many times, but I think there's no one in the room who in the 2-day period of time has questioned your qualifications. There have been some dissenters. My colleagues promised a fair and respectful hearing. Most, including my Republican colleague, Senator Grassley, followed that admonition. He always does. But there were a few obvious glaring exceptions, and I'm sorry for that. But your patience, dignity, and grace in the face of what was frankly some offensive treatment is a real testament to your judicial temperament. To your mom and dad and the Brown family and your Chicago lawyer brother, I thank you for being with us and being part of this historic occasion. Dr. Patrick, I don't know if surgery is any easier than this, but I imagine that you want to get back to it. And I just want to say a word to Layla and Talia, if she's here or she can hear us. You got a great mom. You really do. And what she's been through in the last couple of days, most people would not even consider going through 1 minute. But she is strong, she's caring, she's kind, and you're lucky to have her. And we're going to be lucky to have her on the Supreme Court. So we've got a little bit of work to do. Incidentally, I could go through the list of all the invitees that have been filing in and out of the room behind you, wanting to be here for a moment to share this history with you. I will let you in on something which you may know. Tomorrow we're going to announce that you've been rated unanimously well qualified by the American Bar Association. That's the highest possible rating. We're going to conclude the public portion of this hearing and convene in Dirksen 226 for a closed session for discussing the background investigation. It should only take a minute or so. And I have discussed this with the ranking member, Senator Grassley, and for the information of all members, the committee will meet in executive session to consider Judge Jackson's nomination to the Supreme Court on this Monday, March the 28th at 3 p.m. And with that, the committee stands in recess. Thank you.
Thank you.
The meeting is right now.